Now, we talked about the differences in political systems, differences in economic systems. Now let's talk about differences in legal systems. Again, it is very important to understand that those three are not the same and do not necessarily have to come together. It is true that countries that are economically free tend to be also politically free and tend to have a similar legal system, but it doesn't have to be. So you can have a country with a free market economy but, for example, dictatorship, or you can have a country with, um, for example, a democracy, but not a free economic system, so where the state still controls much of the economy. Likewise, regardless of which system you have, free market or planned economy, if you have democracy or dictatorship, you can still have different legal systems. And so the three main types are common law, civil law, and theocratic law. And so there are some interesting differences among those systems, and it's not even possible to say, or at least in my opinion, it's not easy to say which one is the best. So each one has some pros and cons. So let's look first at the differences between the common law and civil law. So those of you who don't know, common law system still exists in many countries, in the United States first and foremost, but also in Canada and pretty much all other former colonies of Britain. So including Britain itself, but also Australia and some other smaller colonies. Civil law exists in most other countries, all of Europe and pretty much most of the rest of the world. And so there are very important differences between these two systems. First and foremost, common law system relies on precedent, right? So in civil law, the law is what's written in the book. In common law, the law is what's in the previous rulings. How should I explain that? Something like this. So basically, when you have a European country that has civil law, the way the law works there is a bunch of smart people get together, look at all available evidence and historic documents, and they write the law. And they would say, okay, here is the criminal law, and here is all the possible types of offenses, and here is how much should be given for each of the offense in terms of the years. And so they basically codify everything. And so then when the judge is making the decision, the judge needs to open the book, and again, it can be a much bigger book, find the relevant situation, not a case, not what happened in the past, but find a description of the relevant situation, situation we have at hand, and then say, okay, robbery with assault weapon in a group of people, when so much was stolen, equivalent to this and this. Okay, for an offense like this is what needs to happen. We give this person 5 years and whatever the sentence is. And so all the answers would be in this one universal book that was written by smart people. In common law, it's different. So there are still some rules, obviously, about how the law works, and those rules are obviously codified in books. But when deciding whether the person is guilty or not, and whether and how the person should be punished, the kind of ultimate decision is written in the previous rulings. So the judge in that case, so there is no book really that says what should happen in each of the possible cases, but the hearing would not be finding a relevant case in the book and reading what's prescribed as a punishment for a given offense, but going through many, many, many previous rulings and cases, finding similar cases. So when somebody committed a similar crime, and then looking what that person, how that case was decided, guilty or not guilty, what kind of punishment the person got, and then administering the same punishment and the same procedures to the person who is now on the stand defending himself or herself. So that creates all kinds of peculiarities about how this legal system works. So for example, in the civil law system, the rules are really simple. You kind of have a book, you study for this book, and you essentially know how to decide just about any possible case. In common law, the situation is extremely complicated. First of all, you have not even thousands, probably millions of cases by now, when you look at the whole history of the country and all of those rulings. And so you have so many different cases, and because at least before, the electronic systems were not developed, and no judge or no lawyer could potentially know or conceivably know all of the cases. Similar situations often were ruled somewhat differently, or maybe very differently. And so that creates a confusion, because which of the cases should you use as a precedent for the case at hand? You can literally find sometimes cases that were decided differently. Second, the ruling itself becomes a challenge, because it's almost like a game or a dance between the lawyers and the judge and everybody else involved in trying to select the cases that support your argument. So the lawyers are trying to find similar cases where the decision was in favor of the defendant. The prosecutors are trying to find cases where the decision was against or punished the defendant. And so they're trying to present their cases, essentially trying to convince the judge to go one way or the other. And then on top of that, you have all those overlaps in jurisdictions and historic time periods. And sometimes it's not so easy to determine even if the case at hand is a good precedent, because maybe it happened in a different county or in a different state, or maybe there were all kinds of other confounding factors. So very, very complicated. And so that obviously leads to the difference in the options or the decisions. So when a judge in a civil law country writes an option, or kind of writes up the decision and logic behind it, it's usually a relatively simple document. This is what happened, this is the case described in the book, and this is or situation, and this is the ruling prescribed in that case. That's it. Whereas in common law countries, judges often have to write pages and pages and pages, probing every possible relevant case, explaining how one is more relevant here than the other one, what applies here, and then, so the explanations are very, very long. Likewise, because in the common law countries, like in the United States, the system is very complicated, the judges tend to be elected from very experienced lawyers. So people have been in the system for a while and not only gained a lot of experience, but also gained certain credibility. Because as I said, in many cases, the decisions are, I don't want to say subjective, but there is definitely a lot of room for interpretation. And so it has to be a person that has certain level of credibility when making those kinds of decisions. Whereas in, for example, Europe, where it's a civil law system that is much simpler, a judge can be just anyone who has a law degree. Like literally people can become judges right out of law school. So you get out of the school, you apply for a job as a judge, and you can get it. The process is also very different. Like, for example, in Europe, again, where it's simpler civil law, so there are no big battles in court, at least not, about relatively common cases like, murders and, robberies. So there may be some ambiguity as to, the proof. But what to do with that and what kind of cases should apply here, that's pretty much not a question. So there is really not much need for a lawyer in that respect. So it's more a question for the police, do you have the evidence or not? But how to process the case, that's not a very difficult matter. Whereas in the United States, for example, again, if you've seen any movies about the U.S. Legal system, lawyers, Devil's Advocate, Philadelphia, what is a case? So all kinds of different cases or movies about lawyers. There's always a scene in those movies where a lawyer, brings a stack of like a big stack of books and sits all night with a big mug of coffee going through those books, and then by the morning finds very strong relevant cases that were ruled in favor of the lawyer's defendant, and argues those cases very effectively in court and wins the case. So in Europe, you still can win and lose in a sense, but there is really no need to play this complicated game. So in the United States, as a result, the lawyers have to be not only very smart. I mean, I guess it does require a little bit more processing, information processing power, but also, convincing. They have to be almost like actors, trying to convince the jury as opposed to present evidence per se. So likewise, again, because in the United States or in common law countries, the situations are much more complicated because of all those, relevant cases and precedents and all of that. You often have a big element of subjectivity in the judgment, and that's why the jury of peers becomes very important, because even with a jury of peers, people often may have doubts as to whether or not the decision was fair, given how the system works. So jury of peers gives that process, that decision, more credibility and more reliability in a sense. Whereas again, in countries with the civil law systems, jury of peers are not really that common. Still used in some extreme cases in some countries, but there is definitely much less need for that. So definitely very different in that respect. So which one is better? Well, some people say that the common law system is more fair because, your sentence presumably is consistent with the sentences that people who did the same offense in the past received. So you're not punished more or less than people who did the same, act were punished before you. Does it always happen? Well, we know about all kinds of irregularities in the system. We know that, the strength or the brilliance of your lawyer can greatly affect the outcome of the case. Your appearance, your race, your age, your likability, even the time of the day when the judges are making the decisions, all can have an effect on your sentence. I'm not even talking about some other, cases of literally corruption that are known, and that's a whole different story. But yes, and judges tend to be more lenient after lunch, apparently. So studies show that cases that have been ruled after lunch get lower sentence than cases that were ruled before lunch, when the judge is kind of hungry or towards the end of the day. And so in Europe, that seems to be, so is it fair? As an idea, yes. In practice, well, the ambiguity, subjectivity, and freedom of interpretation often makes it actually a little less fair, one would argue. In the civil law system, it's probably a little bit more consistent, but then again, the written laws change from time to time, and literally what was, an offense in the past becomes no offense today, and the other way around. What's interesting, though, that in the United States, it's actually a mixed system. So many people say that it's only common law system. Yes and no. So technically, it is a common law system overall. But for example, in civil law, most of the proceedings are regulated actually by kind of civil law-like regulations. So all those tarts, the civil liability, responsibility, regulations, copyright, much of that is actually regulated by written laws, much like in the civil law system. So it's not a pure precedent law. So there are some areas of law that are essentially behaving or acting just like in civil law. But, that's the difference in pure sense. And so here's a question that is likely to appear on the exam. Let's see if you can answer it. So which type of legal system is in the US? And the answer obviously is common law. Now, let's talk a little bit about the laws that differ most from country to country. And so I'll include a video here, for example, about counterfeiting in China. But when I ask this question of my students, most of them would think about some sort of criminal offenses. Like for some reason, every time I ask it in my class, so what laws are most different from country to country, students always talk for some reason about chopped hands. Chopped off hands, like, in some countries when you steal, they'll literally cut your hand off. But the truth is, and remember that because there will be a question on the exam, that the laws pertaining to criminal offenses are actually remarkably consistent around the world. Just about in every country, stealing is wrong, killing people is wrong. So in most countries, the kind of more traditional criminal offenses are more or less consistent. I mean, yes, you can get many more years in prison for the same offense in one country versus another. But I don't think there is any country on the planet where, for example, theft is not a criminal act, or murder is not a criminal act. But there are some laws that are very punishable, strictly punishable in some countries, and not punishable in others at all. Like, for example, copyright. So, for example, the United States or Europe, they take copyright extremely seriously. So if you write something and somebody copies it, the person literally can go to prison or pay a huge fine. Intellectual property, so protected very, very strongly. If you make a shoe with a Nike swoosh on it, and you are not Nike, obviously an action will be taken against you. It is a criminal offense. There are some other countries that don't even have copyright laws. not only that they can be lax and very very lenient, there may be literally no laws in place for copyright. And so, for example, China, we used to talk about it a lot. Now, obviously, China is toughening its copyright laws, and definitely the situation is dramatically improved compared to where it was 10, 20 years ago. But not so long ago, China had an almost complete disregard for copyright law. And so movies, software, brand names were copied left and right, and no prosecution whatsoever for that. Product safety and liability. Again, in some countries, like in the United States, you walk into a store, you slip on the wet floor, break your arm, and sue the company for millions of dollars and win. Or order a cup of coffee at McDonald's, spill it at your body, burn it, sue, and win a huge settlement or a huge compensation. Or buy a bad product, get sick, sue the company, and again, the company has to pay a huge fine. In other countries, these laws literally either don't exist or not enforced or are much, much more relaxed. Again, for example, in Russia, if you walk in a store, slip on the wet floor and break your arm, they'll just kick you out probably. And, I'm not saying that they will laugh at you, but it would be extremely unlikely that you would get a huge compensation from the store. So any type of safety and liability obviously wouldn't be prosecuted to the same way and to the same extent as it would be in Europe or North America. Antitrust, anti-monopolistic monopoly laws, again, in some countries don't exist, in some countries are very strong. I'm not sure if you have noticed, but Google, Microsoft, Facebook, they get into much more trouble in Europe than they get in the United States. So the antitrust, anti-monopoly laws are much, much stronger, for example, in Europe than in most parts of the world. And so any sign of monopolizing markets, in some countries it would be affected or would be prosecuted very severely, especially when there are some signs of price collusion or market manipulations. And in other countries, nobody cares. So price fixing, stock market manipulations, all kinds of other things that monopolies do. In some countries, it would be perfectly fine and not even a punishable offense, whereas in other countries, you can go to prison for this. And finally, taxation and financial laws. Again, not only that the types of taxes paid are different in different countries. Like, for example, Europe has VAT, value added tax. The United States has a sales tax, which is a very different tax. It's calculated differently. It just works differently. But also the amount of tax, the level of taxation, what's allowed and what's not. In some countries, you cannot, for example, hold assets in foreign currencies. Or you cannot own assets overseas, or there are some regulations on whether or not the money can move across the border. So in some countries, it's very, very fluent, very, very relaxed, especially when we talk about countries that are known as tax havens. So almost no regulations in that area, whereas in other countries, it's extremely strict. So and you can literally be extremely severely punished for breaking the tax law, or the way you pay taxes may be very different. And so when it comes to copyright protection and private property, again, we used to do a lot or talk a lot about China not respecting copyright. Again, this is to a large extent outdated information. So China, now that it has a lot of production and that it sees its own manufacturers growing and becoming more prominent in the world, all of a sudden protection of copyright intellectual property becomes more important, because that's how you stimulate competition. If there are no copyright laws in place, there is no reason to innovate. You just wait until somebody comes up with the idea and you steal it. And so again, at the time when China was buying all the technologies overseas, there was no incentive to protect them, and there was every incentive to allow locals to copy those technologies. But now that China has literally world-class companies, all of a sudden, for them, it's an issue, and they take it much more seriously. But not so long ago in China, I was in China a number of times, and you could literally buy any knockoff right there on the main street. So you go to some parts of Beijing, and at that time, at least 10 years ago, 15 years ago, you could literally buy any counterfeited brand product, from Nike to Levi's, just about anything. Any software, so you could buy like a Windows CD. At that time, it was still on CDs, like for $2. So all kinds of counterfeits. One of the stories that made kind of news, I remember a few years ago in 2011, in China, apparently not only the products themselves were counterfeit, even the whole stores were counterfeit. It was right at the time when Apple was launching Apple stores. Again, those of you who are older may remember that Apple stores are a relatively recent invention. So they appeared right around the time when iPhone was released. So it must have been like 2008, 2009, maybe 10. And so in China, there were some stores allegedly that looks like an Apple store. The employees thought that they worked for Apple, but in reality, it was just a counterfeit. So people just opened the store, designed it like an Apple store, said it's an Apple store, but it had nothing to do with Apple. So even that was, yeah. Finally, one interesting example of the differences in the laws, which is banking laws. And again, banking is kind of, it's been around for millennia. In fact, I just recently read a very interesting book called The History of Money or History of Capital. Very fascinating. Money has been around for, millennia. And it's a very interesting, domain of life. But in most countries, it operates kind of more or less the same. So there are people who have money, there are people who need money, and there are banks that sort of are in between. They take money from those who have too much of it and pay interest for borrowing the money, and they give the money to the people who need them and charge interest. And so they charge a little bit more for lending money than for borrowing, than they pay for borrowing money. And so that difference, that's how banks make their money. But there are some countries that have different rules about banking. And so Islamic countries are an example. So in Islam, it is against the Quran to charge interest on loans. And so that makes it a little challenging to lend money. So if the rule is that you cannot charge people when you lend them money, that removes the incentive to lend money. Why would you give money to anyone if you cannot make money on lending money? And so it probably was okay, although it could have stifled the economic growth in the past. But in today's economy, it's a major impediment to economic growth. And so some countries actually are trying to develop banking systems that obey or kind of work with the Islamic law. And Indonesia, if you didn't know, that's the largest, the most populous Islamic country. So when we say Islam, many people think, Saudi Arabia, maybe, the Middle East. But actually, Indonesia in Asia, it's an Islamic country, and it has more people than any other country has Muslims. And so being kind of far away from the Middle East, this country has a nice and kind of curious mix of, traditions and cultures. And so they're more innovative when it comes to Islamic banking. And so here is a link to the Wikipedia article if you want to read about it. It's a fascinating topic, but I'll tell you my own experience with this. When I came to Greensboro 10 years ago, 11 almost years ago, I first bought a townhouse. And then after living in it for a couple of years, we decided to buy a full house, regular house. And so we were selling a townhouse. And one of the customers comes to me and says he's from, I think it was United Arab Emirates, if I remember correctly. And he wants to buy my townhouse, but he asks if I would be willing to kind of have a deal with him directly about financing the purchase. And I was like, whoa, I don't understand what you're talking. Tell me more. And he says, well, I'm from an Islamic country, and according to my religion, I cannot pay interest on loans. And so I do not have enough money to buy the house with cash, so I need to borrow some money. But I cannot go to a bank and ask for a traditional mortgage because mortgages obviously have interest on them. And that would be against my values and religion. And so maybe we can do something with you and buy it from you, but in a way that I will not pay all of the money upfront, but over time. And so I understand that it will cost you. So what we can do is we can, let's say you want to charge me, let's say 5%. Why don't we add that amount to the total price of the house? So you will sell it to me for more, and then I'll pay that money to you, that higher price. But it will not be the principal plus interest. It will be just simply a higher price that I will pay you over time. And so this way you kind of get a little bit more money. I pay for the house over a period of time, and there is no interest involved. Unfortunately, at that time, I couldn't afford this deal because, it was only a couple of years before I had graduated with a doctorate degree, and I just started working as a professor. Just, didn't really have much savings, and I was buying a house for myself, so I needed that cash anyway. But that was an interesting situation. And so Indonesia has a banking system that actively experiments with offering types of, again, they don't call them loans, but like profit sharing and all kinds of other arrangements where people with money can help people without money get some sort of interest on that, but it wouldn't be the traditional interest on loans as it works in our system. So yeah, that's something for you to consider. Now let me see here. Oops. One of the disadvantages here. Yeah, let's do this.